If you would, please come forward, state your name, who you're here with, and what your official position is with respect to the measure, please.
Thank you, Mr. Chair. My name is Kelly Cook. I am here in my individual capacity, and I'm going to testify for the bill. I am a civil litigator in Houston, and I had the opportunity to represent a person who was involved in a revenge porn type situation. To speak specifically to you, Representative Leach, it was an instance where a person's phone was stolen. This was not an instance where they texted pictures to someone that then got out into the wild. It was a theft. I am specifically testifying for this bill because of the civil remedy that is provided. I think that the civil remedy is very important because as the law stands right now, if Ms. Snoops were to walk into my office with her situation and ask me what I could do, I would tell her that there's about 5 possible causes of action that I could try to work on, go through my O'Connor's Texas causes of action and try to find one that could help her. Since she wasn't married, there's no fiduciary duty that would have been breached, and even if it is a spousal situation, once a divorce proceeding is engaged, that fiduciary duty goes away, so you don't even have that claim. You could claim that there's an intentional infliction of emotional distress, but in Texas that is what we call a gap filler tort, and our Supreme Court has said that if there is another cause of action that more correctly fits the conduct, you cannot proceed on an intentional infliction of emotional distress claim. So we go to the 2 torts that are most correct, that most closely fit the conduct in Texas. Those are invasion of privacy by intrusion on seclusion and invasion of privacy by disclosure of private facts. The reason that these are not enough is because under the intrusion on seclusion, there has to be an intrusion. There has to be some element of spying or a violation. And some, unlike the case that I had, some of these are instances of voluntarily shared pictures that are then transmitted without consent. That then would make that tort unavailable. There's also the disclosure of private facts. And a very concerning fact is for me, when my client came in and I got my Texas O'Connors out and I looked at what tort I could rely on and discovered that no reported Texas case has ever affirmed a damage award under a public disclosure of private facts. It has never happened. And so what I told my client is that we don't have very much here. Now, fortunately, what I was able to do was rely on the fact that the phone was stolen, and I brought a tort of conversion. And that was my lead claim to help me bring that case to a resolution. If I had the tools in this bill, I probably could have done more, and I certainly would have been a lot more comfortable with my ability to proceed against the bad actors. To address just a couple of the things that I've heard other folks talk about, one of the, I think, the important reasons that we have a civil provision for this bill, if Mr. Bennett is right, and I don't think he is, but if he is right and the criminal statute were to fall, the civil statute would remain. We would still have people who were able to go forward and stop this behavior while the legislature was able to put together another criminal bill. And powering a civil cause of action will create the most motivated prosecutors that there are, and that is the victims and the victims' lawyers. We will be able to go after these people and shut them down, and there will be nobody that wants to do it more than us. With regard to the improper photography issue, in my case was exactly what you were talking about, Representative Leach. It was the transmission of those pictures were not to sexually gratify. It was specifically to harm my client's employment. Basically, they got these pictures off of the phone, then transmitted them to my client's boss to basically say she's a bad person. It was not about sexually gratifying anyone. It was about harming my client. And then I think, Representative Hunter, you may have some questions on the civil versus criminal, and so I'd like to give you an opportunity. And, of course, anyone else.
Yes, sir. Representative Hunter.
What is the civil remedy?
The civil remedy would be a cause of action against anyone who participated, promoted, shared. It would allow us to get mental anguish damages without having to show a physical manifestation of harm, which is technically the remedy that's available under the public disclosure of private facts. Arguably, we would potentially have a claim for punitive damages. At a minimum, we would have that mental anguish element.
So it's primarily a mental anguish statute?
Yes.
All right. Now, does that require intent?
I do believe that the way the statute is drawn right now does require intent.
Because if you don't have negligence, you have no insurance triggering.
That is correct. I would certainly support and even great.
I'm not trying to help you all out here, am I? But you may want to take a look at the civil so you have some teeth. And I do agree with the comment that I think the civil action is not what he was arguing against. It was the criminal side. So on the civil, you might take a look at the statutory so you have a standard that triggers economic return rather than a judgment that has nothing.
That's absolutely correct, Representative Hunter, and I will certainly make myself available to any
Well, I'm trying to whisper to you to get to the author who sits in front of me on the House floor. So I think you had a real good, lively discussion here. I think that take a look at the civil side so that you do have that part of the puzzle here. And I think that you can get the correct language in the bill.
Thank you, Representative Hunter. I will make sure to pass that on to the author.
Other questions, members? If not, thank you.